Thank you for joining us for this webinar on electronic monitoring with victim notification. I'm Brian Farrell. I'm the Clark County District Court Administrator.
And I'm Sergeant Tanya Wolstein with Vancouver Police Department.
Public safety has been a big deal to me for a long time. Keeping our public safe is really one of the #1 things that government really should do. As a child, I witnessed domestic violence in my own family. Watching this and seeing how basically it affected my mother and my sisters and me, I just never want to be in that situation, never again. So I started doing some research. I started digging into the statistics here in Washington State, and those were shocking to me.
Short of educating and teaching men not to harass women, I think the best way to protect women is to provide them with the GPS. The technology works in 2 ways. There are stationary, namely technology that protect the place, the victim's home or place of work, and the notification one that we call the mobile one, that it's not attached to a particular place, but rather to a person. So wherever she walks with it, she is protected. If the abuser is within a certain range, she will be notified, and he will be notified to get away from this area.
Senate Bill 5149 is the bill that passed in 2020 that gives the capability of this new technology for electronic monitoring of real-time notification. I ran the bill in 2018 and it failed. Ran it again the following year and it got through the Senate and it failed again in the House. And then in November of 2019, we had the tragedy down here in Vancouver. Tiffany was compassionate, loyal. She did everything for her kids. She wound up in a situation where she had been going through years of abuse from her husband. Tiffany was sitting in the parking lot in her car as the kids got into the car. Her estranged husband was sitting in the parking lot for 20 minutes and then got the courage to drive up in front of her car, block her car, get out of the car, walk over to the windows and shot her several times through the windows of her car with her kids in the back seat.
When women are killed, it's usually by an intimate partner. Abusers know everything about the woman's habits, schedule, where she's likely to be. It makes it very easy for them to harass her. Having this application with her protects her wherever she goes. And they've talked about it. I got my life back. I'm free again. My kids can play. My neighbors are not worried about me. So it's definitely has changed the quality of life of women who are protected by the technology.
It is the element of surprise that usually takes the victim off guard. Having this technology available will help the victim to gain more control over their lives, even if it's just a few minutes. It's just empowering them with whatever we can.
In June of 2020, the Washington State Legislature passed the Tiffany Hill Act. In July of 2020, we formed a planning team to develop an electronic monitoring with victim notification program. The planning team is one of the most crucial and impactful parts of developing this program, and it included judges, court administrators, prosecutors, victims advocates, probation and pretrial release staff, all county law enforcement agencies, 911 dispatchers, and defense counsel.
Once we formed our team, we sent out invitations to our first meeting. During this meeting, we discussed information about the law, the scope of the project, next steps, answered questions, and set up live demonstrations from multiple vendors.
Our planning team spent 9 months testing multiple products. We wanted to learn about the technology and what was available to us so that we could adapt it to our program. Over those 9 months, I carried around an ankle monitor, and Sergeant Wolstein downloaded the victim notification app on her cell phone. We created exclusion zones and purposely violated those exclusion zones so that we could test alerts and other functionality of the program.
After testing multiple devices, we came up with a list of features we wanted to make sure were included with our ankle monitor devices. One is a long battery life. Second is that the device would vibrate and alert the monitored individual when the battery was low. Two-way communication between the monitoring center and the restrained party, and the ability for law enforcement to call into the ankle monitor device. An audible alarm when the exclusion zone is violated, and the ability to put the device into pursuit mode to upload GPS points every 15 to 20 seconds.
In addition to testing out the features of our ankle monitor, we also tested out features in our phone application. We wanted to be sure that victims were receiving immediate push notifications, timely text message reminders, and timely email alerts.
Another important feature of our program is the Monitoring Center's website. It allows law enforcement to have immediate access to the site and the monitored individual's location without having to write a warrant. This is very important for timely apprehension of the monitored individual upon violation of the protection order.
Another critical component of our program was the notifications. We wanted to make sure that we had customizable notifications for any exclusion zone violations, buffer zone violations, any device tampering, any low battery alerts, or anytime the device shut down. As previously mentioned, I carried an ankle monitor around with me for 9 months during the testing process, and Sergeant Wolstein had the victim notification app downloaded on her phone.
During that time, we conducted several tests, some intentional, some not. For example, one night I was driving along in my patrol vehicle on night shift and drove past Brian's house unknowingly.
And the 95 decibel siren went off on the ankle bracelet in the middle of the night, waking my entire family up.
So be careful when you're doing your testing, because that could happen to you. During the live testing and demonstrations, we learned several things. One is that standardized exclusion and buffer zones would be helpful in programming the devices and giving the victims enough time to institute their safety plan. In addition, having monitoring center read a script to dispatch ensured that the dispatcher would understand that this was a restraining order in progress call and not an alarm or some other kind of alert. Law enforcement needed training on how to use the system and access the law enforcement database.
The next step in the implementation phase was to ensure we had protocols in place that required the device to be installed in jail prior to release, that the vendor had a copy of the protection order, and that we worked with victims advocates to ensure we had the proper addresses for any exclusion zones.
Another protocol we developed was to have the vendor sit down with the monitored individual and show them paper with a map printed and the exclusion zone showing exactly where the monitored individual is prohibited from entering. The monitored individual then signs the paper saying that they understand where they are no longer allowed to go and that they will abide by the provisions listed in the protection order.
Response protocols for stationary exclusion zone violations consist of a monitoring center notifying dispatch, dispatch creating a call of a restraining order in progress, law enforcement logging into the system to track the monitored individual, the monitored person's device alarm activation, the monitoring center calling the device, letting the monitored individual know they are in an exclusion zone, and that the victim is notified via push notification, text message, and email.
The protocol for a mobile exclusion zone violation differs significantly from a stationary exclusion zone violation. The victim is notified by a push notification, text message, and email. The monitored person is not notified in any way, and law enforcement is not called. The reasons that the protocol differs so much is that we do not want to have a circumstance where the victim's safety is compromised by the monitored individual driving past places he knows the victim may be, not being in violation of the order because of lack of knowledge of the victim's location, and then returning later to possibly harm the victim. In addition, incidental contact occurs quite often. In this case, the monitored individual may be driving on the freeway while the victim is at a location nearby with no intended contact and no actual contact.
Victim education is a crucial part of this program. Identifying an agency such as victim advocates to provide education to victims about the capabilities and limitations of this program is essential.
we recommend that you identify the data you want to track in your program before implementation. Track the data throughout your program and make adjustments as necessary.
Prior to the launch of any electronic monitoring victim notification program, you should identify a training team and send that training team out to train all community stakeholders. This includes all law enforcement agencies, dispatch, prosecutors, defense attorneys, victims advocates, courts, and pretrial release.
Finally, we would like to remind everyone that this is a tool to enhance victim safety and does not guarantee safety, as there are several things that can happen to interfere with cellular reception or GPS monitoring equipment.
We would like to thank you for joining us on this webinar for electronic monitoring with victim notification.
And please feel free to reach out to us if you have any questions.